You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. Employment privacy law addresses the full arc of the employment relationship, beginning even before an individual is hired. At its foundation is the principle of reasonable expectation of privacy, a concept that shapes how courts, regulators, and employers define boundaries between organizational oversight and individual autonomy. In practice, this means employees and applicants can expect a degree of privacy in certain contexts, such as personal belongings, medical information, and protected communications, while also understanding that workplaces may monitor activity for legitimate business or safety reasons. For learners, this foundation demonstrates how privacy in employment is not absolute, but situational. Employers must balance operational needs like productivity, safety, and compliance with fairness, transparency, and respect for individuals. Privacy expectations therefore hinge on context, clarity of notice, and alignment with broader legal protections that govern equality and dignity in the workplace. Anti-discrimination statutes provide the core anchors for fair hiring and employment practices. Title VII of the Civil Rights Act prohibits discrimination based on race, color, religion, sex, or national origin. The Americans with Disabilities Act extends protections to individuals with physical or mental impairments, requiring reasonable accommodations while restricting unnecessary inquiries into health conditions. The Genetic Information Non-Discrimination Act further prevents employers from requesting or using genetic data in employment decisions. For learners, these laws illustrate how privacy and equality are intertwined. Protecting applicants and employees from inappropriate or irrelevant questions ensures that hiring and workplace decisions focus on ability and qualifications rather than personal attributes. These statutes collectively demonstrate how legal frameworks create privacy boundaries not only to protect sensitive data, but also to ensure fairness and prevent entrenched bias in employment relationships. Oversight of employment privacy and compliance is distributed among multiple federal agencies. The Equal Employment Opportunity Commission enforces anti-discrimination laws, investigates complaints, and issues guidance on proper employer practices. The Department of Labor oversees wage and hour protections, leave entitlements, and worker benefits, many of which involve privacy considerations. The National Labor Relations Board ensures that employer monitoring or discipline does not infringe on workers' rights to engage in protected concerted activity, such as union organizing or collective bargaining. The Occupational Safety and Health Administration enforces health and safety protections, often requiring sensitive data about employee injuries or conditions. For learners, these overlapping roles illustrate how employment privacy sits at the crossroads of multiple policy areas. Privacy in employment is not siloed but integrated across equality, safety, and labor rights, making governance complex but essential. Automated employment decision-making tools have introduced new risks in hiring. Many organizations now rely on algorithms to screen resumes, rank applicants, or even evaluate recorded interviews. While these tools can improve efficiency, they also risk amplifying bias if training data is skewed or transparency is lacking. For learners, this development highlights the need for accountability in technology. Algorithmic decision-making can obscure discrimination behind opaque formulas, making it harder to detect. Employment privacy is not just about safeguarding sensitive data, but also ensuring that the tools processing that data are fair, explainable, and auditable. This intersection of technology and law reinforces the importance of vigilance in balancing efficiency with equity in modern hiring systems. Bias audits and transparency measures are increasingly being required by state and local laws for automated hiring systems. These audits evaluate whether tools have disparate impacts on protected groups and whether their criteria are justified by job relevance. Transparency obligations may also require employers to disclose when algorithms are being used and what data points are evaluated. For learners, this illustrates how privacy is not limited to secrecy of information but extends to how data is used and understood. Requiring audits and disclosures ensures that applicants are not unfairly excluded by hidden algorithms and that employers remain accountable for the fairness of their technological systems. Bias audit frameworks embody the principle that lawful hiring must be both privacy-conscious and substantively fair. Background screening is another area where privacy considerations are paramount. Under the Fair Credit Reporting Act, employers must obtain written authorization before conducting background checks and must provide notices if adverse action is taken based on the results. Applicants must also be given a copy of the report and an opportunity to dispute inaccuracies. For learners, this process highlights the importance of transparency and accuracy in protecting personal data. Employers may need to verify identity, criminal history, or creditworthiness, but they must do so under rules that prevent surprise and ensure fairness. Privacy protections here act as safeguards against errors, misuse, and unjustified exclusion from employment opportunities, reflecting how personal data governance directly shapes individual livelihoods. Some employers rely on personality, psychological, or integrity testing during the hiring process, raising questions about privacy and fairness. Laws require that such tests be demonstrably valid and job-related, avoiding inquiries that unnecessarily intrude into protected areas such as mental health or religious beliefs. For learners, this underscores how privacy boundaries prevent overreach. While organizations may have legitimate interests in assessing fit or reliability, these interests must be pursued in ways that are scientifically justified and legally defensible. Testing that strays into sensitive domains risks violating anti-discrimination laws and eroding trust, showing how privacy safeguards help keep hiring tools aligned with both fairness and relevance. Polygraph testing provides an even clearer example of statutory privacy protection. The Employee Polygraph Protection Act generally prohibits private employers from using lie detector tests for pre-employment screening or during employment, with narrow exceptions for certain security or investigatory roles. For learners, this prohibition highlights how law draws bright lines where privacy risks are considered too intrusive. Polygraphs are not only scientifically unreliable, but also deeply invasive of personal thought and emotion. By barring their general use, Congress affirmed that some tools are inconsistent with the dignity of workers and applicants, demonstrating how privacy protections can be categorical rather than conditional when fundamental rights are at stake. Drug and alcohol testing is permitted in many workplaces, but privacy considerations shape how it is conducted. Employers must have clear policies, provide notice, and apply tests consistently to avoid discriminatory impact. Confidential handling of results is also required, ensuring that sensitive health information is not disclosed beyond what is necessary. For learners, this demonstrates how privacy principles of notice, consent, minimization, and confidentiality apply even in contexts where employer safety interests are strong. Balancing workplace safety with employee dignity requires structures that limit intrusiveness and maintain trust, ensuring that testing policies support legitimate purposes without drifting into unnecessary surveillance or stigmatization. Social media screening has become a contentious aspect of hiring. Employers may review public profiles to gauge character or fit, but they must avoid practices that infringe on protected concerted activity under labor law or reveal protected characteristics that could bias decisions. Some states restrict employers from requesting social media passwords or private account access. For learners, this highlights how digital footprints blur personal and professional boundaries. Privacy principles remind employers that not everything publicly visible is fair game for employment decisions, and that fairness requires restraint. The use of social media in hiring illustrates the growing need to balance transparency about applicants with respect for autonomy and freedom of expression. Data retention, minimization, and deletion policies also apply in hiring. Applicant records that are not needed after recruitment should be securely deleted, particularly for unsuccessful candidates. Retaining unnecessary personal data increases risks of misuse or breach. For learners, this demonstrates how lifecycle governance applies outside litigation or surveillance contexts. It also governs HR. Minimization protects not just privacy but also organizations, reducing liabilities and demonstrating compliance with privacy statutes. By limiting retention, employers reinforce fairness and respect for applicants, recognizing that data collected during the hiring process should not linger indefinitely without purpose. Recruitment vendors and applicant tracking systems bring another layer of privacy governance. Employers must ensure that contracts with vendors include data protection clauses, specify retention periods, and prohibit unauthorized use of candidate data. Vendor oversight is critical because outsourcing does not absolve employers of responsibility for privacy compliance. For learners, this reinforces the theme that privacy obligations follow the data, regardless of where it resides. Vendor agreements operationalize statutory duties, turning abstract principles into enforceable obligations across organizational boundaries. Recruitment ecosystems demonstrate that privacy governance in employment is collective, requiring vigilance across providers, platforms, and partners. Unionized workplaces introduce unique privacy considerations. Collective bargaining agreements may restrict monitoring or establish procedures for disciplinary investigations. Employers must respect these agreements and ensure that privacy-related policies are negotiated rather than imposed. For learners, this reflects how privacy governance intersects with labor relations. In union settings, privacy protections are shaped not only by statutes and policies, but also by negotiated rights. This demonstrates the flexibility of privacy as a legal and cultural construct, adapting to different workplace governance models while maintaining core principles of fairness and respect. Finally, pre-employment privacy obligations often include notice, consent, and acknowledgement forms. Applicants may be asked to acknowledge policies on monitoring, background screening, or data retention. For learners, this step illustrates how transparency builds trust. Consent forms not only satisfy legal requirements but also educate applicants about what to expect, aligning expectations and reducing surprise. Informed consent reflects the core privacy principle of autonomy. Individuals deserve to know how their data will be used, by whom, and for what purposes. Even in the inherently unequal power dynamic of employment, consent mechanisms provide a measure of control, reinforcing dignity and fairness at the outset of the employment relationship. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. Employee monitoring is one of the most visible areas where privacy expectations are tested. Employers often monitor computers, email, telephones, video surveillance, and even network traffic to protect productivity, security, and compliance. Under U.S. law, such monitoring is generally permissible if notice is provided, and if it serves legitimate business purposes. For learners, this illustrates how the reasonable expectation of privacy shifts once an individual is in the workplace. Personal use of corporate systems may be tolerated, but it is rarely considered private. Proportionality is essential. Constant or invasive monitoring without cause can damage morale, increase legal risks, and erode trust. Clear policies, communicated through handbooks or acknowledgement forms, help ensure that monitoring is understood, expected, and therefore defensible, demonstrating how transparency turns potential intrusion into a managed governance practice. Bring your own device, or BYOD. Policies create additional complexities. Many employers allow staff to use personal phones or laptops for work, but this blurs the boundary between professional oversight and personal privacy. Mobile device management tools may be installed to secure corporate data, but they can also create risks of overreach if they provide access to personal files or communications. For learners, this issue highlights the importance of consent, segregation, and technical controls. Policy should make clear what data the employer can access, how remote wiping is handled, and what safeguards exist to protect personal content. BYOD demonstrates how workplace privacy evolves with technology. Flexibility for employees requires stronger governance frameworks to protect both company interests and individual autonomy simultaneously. Location-based services, wearables, and wellness programs extend monitoring into new frontiers. Employers may track vehicles for efficiency, use badges to log building entry, or offer health programs that collect biometric or lifestyle data. While these initiatives can improve safety or employee well-being, they also raise significant privacy risks. For learners, this demonstrates how sensitive categories like health or geolocation require heightened safeguards. Participation should be voluntary, data should be anonymized or aggregated where possible, and retention should be limited. Employers must also consider anti-discrimination laws, ensuring that health-related information is not misused in employment decisions. Wellness programs and location services underscore the importance of aligning innovative practices with clear consent, transparency, and respect for sensitive personal information. Biometric systems are increasingly used for timekeeping and physical access, such as fingerprint scans or facial recognition. These technologies require careful governance because biometric identifiers are immutable. Once compromised, they cannot be changed like a password. State laws such as Illinois' Biometric Information Privacy Act impose strict requirements for notice, consent, retention schedules, and destruction policies. For learners, biometrics highlight the convergence of technology, privacy, and labor law. Employers must not only protect data security, but also justify why biometrics are necessary rather than less intrusive alternatives. Governance here means demonstrating proportionality. If biometrics are used, they must be managed with consent, clear policies, and safeguards that respect the heightened sensitivity of this unique category of personal data. The Electronic Communications Privacy Act intersects with workplace monitoring by creating exceptions for employers. Organizations may monitor communications on their own systems when conducted in the ordinary course of business, but they cannot indiscriminately intercept personal communications without justification. For learners, this illustrates the boundary between employer rights and individual protections. The ECPA ensures that while businesses can protect their assets and operations, they must do so within constraints that prevent unjustified surveillance. Understanding this balance reinforces the principle that privacy law does not eliminate monitoring but demands that it remain purposeful, limited, and consistent with notice and policy frameworks that employees can reasonably expect. Internal investigations present another area of significant privacy impact. Employers may need to collect emails, examine devices, or interview employees when misconduct is suspected. Due process, documentation, and minimization are essential for defensibility. Investigations must respect employee rights, avoid phishing expeditions, and maintain confidentiality to protect both targets and witnesses. For learners, internal investigations highlight the importance of fairness in privacy governance. Investigative authority is broad, but unchecked intrusions erode trust and risk legal claims. Policies that establish consistent procedures ensure that investigations are handled lawfully, proportionately, and transparently, reinforcing the dual obligations of protecting the organization while respecting the dignity of employees involved. The use of third-party investigators requires further safeguards. External investigators may be engaged for harassment complaints, fraud inquiries, or compliance reviews, but contracts must include confidentiality provisions, retention limits, and restrictions on use. For learners, this demonstrates how vendor oversight principles extend into human resources. Employers cannot outsource responsibility for privacy. Accountability remains with the organization. By embedding privacy and confidentiality clauses into contracts, organizations ensure that sensitive employment data is handled with the same rigor externally as it would be internally. This alignment of vendor management with HR governance reinforces the universality of privacy safeguards across all organizational contexts. Records retention schedules apply throughout the employment lifecycle. Personnel files, performance reviews, payroll records, and disciplinary documents must be retained according to statutory timelines but destroyed once no longer needed. Over-retention not only increases legal exposure but also creates privacy risks if files are accessed or breached. For learners, records retention highlights how employment privacy is as much about minimizing future risk as managing present obligations. Retention policies must be defensible. consistent, and transparent, ensuring that records serve legitimate business and legal purposes without becoming long-term liabilities. Destruction processes, when followed, demonstrate discipline and aligning information governance with privacy values. Termination presents unique privacy considerations. Employers must promptly revoke access to systems, recover devices, and secure corporate data, while also respecting the dignity of the departing employee. Exit interviews should avoid overreach into personal matters, and personal data held on corporate systems must be minimized or returned. For learners, termination highlights how privacy obligations do not end with employment but continue through the transition. Balancing corporate security with fairness ensures that employees leave with respect, while employers protect themselves against risks of data leakage or retaliation. This phase demonstrates the lifecycle principle. Privacy obligations span entry, active employment, and exit alike. Reference practices create post-employment privacy obligations. Employers may be asked to provide information about former employees, but they must avoid defamation risks and disclose only accurate, relevant information. Many organizations adopt neutral reference policies, confirming only dates of employment and positions held to minimize liability. For learners, references highlight the enduring responsibility to protect personal data even after an employment relationship ends. Privacy in this context means ensuring fairness, truthfulness, and proportionality, preventing reputational harm from unnecessary or inaccurate disclosures. Reference governance reflects how privacy is embedded in ethical business conduct as much as in legal compliance. State privacy laws increasingly provide employees with rights to access, correct, or request deletion of personal data. Subject access requests under statutes like the California Consumer Privacy Act require employers to establish processes for responding within defined timelines. For learners, this illustrates how privacy law expands beyond consumers into the employment context. Employers must now view employees as data subjects with enforceable rights, requiring integration of HR, privacy, and IT systems. Access rights reinforce transparency, giving individuals visibility into how their personal data is used and retained. Compliance in this area demonstrates how employment privacy is merging with broader data protection trends, creating new obligations for organizations. Multinational employers face further complexity with cross-border data transfers. Many countries impose localization requirements or strict safeguards for employment data, such as the EU's General Data Protection Regulation. For learners, this reflects how employment privacy is globalized. HR systems often centralize records, but international transfers require contractual clauses, transfer impact assessments, or local storage. Balancing global efficiency with local compliance illustrates the complexity of employment governance in multinational enterprises. Cross-border employment privacy emphasizes the importance of harmonizing legal, technical, and organizational measures to respect both domestic labor law and international privacy obligations. Manager training is essential to operationalizing employment privacy. Supervisors who handle performance data, disciplinary matters, or workplace monitoring must understand the legal boundaries and organizational policies. Training ensures consistency, prevents inadvertent overreach, and embeds privacy as part of workplace culture. For learners, training illustrates how privacy is not sustained by policy documents alone but by awareness at the operational level. Managers are often the first point of contact in privacy-sensitive situations, and their conduct determines whether policies are lived realities or ignored ideals. Building a culture of privacy through training reinforces trust and compliance across the employment lifecycle. Finally, governance and accountability structures must integrate human resources, legal, and security functions. Employment privacy touches every corner of organizational operations, from hiring algorithms to post-employment references. Cross-functional collaboration ensures that monitoring, investigations, and record-keeping are coordinated and consistent. For learners, governance is the anchor of employment privacy. Policies are necessary, but accountability and collaboration transform them into sustainable practices. Employment privacy is not the responsibility of one department, but a shared duty across HR, compliance, IT, and leadership, ensuring proportional monitoring, lawful processing, and fair treatment of employees throughout their journey. In conclusion, Domain IV highlights employment privacy as a lifecycle obligation covering hiring, active employment, and termination. From fair and bias-free recruitment to proportionate workplace monitoring and careful post-employment disclosures, privacy governance ensures that individual dignity is respected while organizational needs are met. For learners, the synthesis is clear. Effective employment privacy depends on fair hiring practices, proportional and transparent monitoring, and disciplined management of records across the employment lifecycle. Embedding governance, training, and accountability ensures that employment privacy is not just legal compliance, but an ethical foundation of the modern workplace. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.